Welcome to Beyond Bare Act. This is episode 5 of our IT Act series, Stolen Identity, Online Impersonation and Digital Privacy. A stolen phone, a reused password, a fraudulent support call and a threatened intimate image may look like one cyber incident. The law does not treat them as one. This episode explains sections 66B, 66C, 66D and 66E. Their exact ingredients, punishments, evidence, landmark cases, and current remedies. For a law student, practitioner, or ordinary digital user, these provisions explain how the law separates a stolen device, identity misuse, technology-assisted deception, and bodily privacy. We begin with Riya's continuing incident and ask why discovering unauthorized access was only the first layer. In episode 4, an old support account entered the platform after its authority had ended. Riya's scholarship file was copied, records were deleted, and we separated Section 43's civil contravention from Section 66's criminal offence. But access was only the first layer. The file contains Riya's identity details. Her password is used on a second service. A caller posing as a platform official asks her to approve a payment reversal. Then a message arrives with an image recovered from an old phone. Pay or it will be circulated. These acts may feel like one cybercrime. Legally, receiving a stolen device, using another's identity feature, cheating by personation, and violating bodily privacy have different ingredients. A threat may trigger another offence before publication. Begin with a map. Section 66. B concerns dishonest receipt or retention of a stolen computer resource or communication device with knowledge or reason to believe that it is stolen. Section 66. C concerns fraudulent or dishonest use of another person's electronic signature, password, or other unique identification feature. Section 66. D concerns cheating by personation through a communication device or computer resource. Section 66. E is narrower than digital privacy generally. It addresses intentional or knowing capture, publication or transmission of an image of a person's private area without consent under circumstances violating privacy. The focus changes from object to identity feature to technology-assisted deception to intimate image and consent. One course of conduct can satisfy more than one provision, but overlap is not automatic. Test each offence independently. That prevents a common examination error. Writing every familiar section number beside a cyber incident without proving its ingredients. Section 66. B matters in markets for stolen phones, laptops, storage devices, and computer resources. The prosecution must identify a stolen computer resource or communication device, then prove that the accused received or retained it dishonestly while knowing or having reason to believe that it was stolen. Possession alone is not enough. Asher buys a used phone from a recognised refurbisher with an invoice and no suspicious information. Dev buys the same model unusually cheaply from an anonymous seller who removes its serial label. After the owner and police notify him that it is stolen, Dev hides it and continues using it. Farhan merely borrows a phone without knowing its history. Price, altered identifiers, source, notice, concealment and later conduct may prove knowledge or reason to believe, but suspicion still requires evidence. A contractual ownership dispute is not automatically receipt of stolen property. Punishment is imprisonment up to 3 years or a fine up to 1 lakh rupees, or both. Section 66C is titled Identity Theft, but its text is more precise. It applies when a person fraudulently or dishonestly makes use of another person's electronic signature, password, or other unique identification feature. Ask: what feature was used? Whom did it identify? What act amounted to use? And was that use fraudulent or dishonest? Copying a file containing Riya's password creates exposure, but Section 66C requires use. Entering it to access her account is the clearest example. Applying her electronic signature to a transaction may be another. Yet every piece of personal information is not automatically a unique identification feature. A common name, public photograph, or address may be personal information without performing the identifying function contemplated here. Context matters. A correct password also does not prove who typed it. The system may show that a credential was accepted. Human attribution needs further evidence. The punishment is imprisonment of either description up to 3 years, with liability to a fine up to 1 lakh rupees. Does an OTP, biometric, account token, email address, phone number, or UPI identifier count as an other unique identification feature? Use a functional test. The statute expressly names an electronic signature and password. For another feature, ask whether it uniquely identifies or authenticates another person in the system and transaction concerned. An account token or biometric linked feature may do so. An OTP may operate inside authentication, but no universal answer should be announced without its system and purpose. A phone number may identify an account in one service and provide only contact information in another. Next, prove use, not merely collection, viewing or possession, and prove dishonest or fraudulent intention. A parent using a child's password with authority to submit a form is different from a stranger using it to divert funds. Classification follows function, authority, conduct, and intention. Section 66 D punishes cheating by personation through a communication device or computer resource. The device is the medium. Personation and cheating are the legal core. Under the BNS, cheating involves deception that fraudulently or dishonestly induces delivery or retention of property, or intentionally induces an act or omission causing or likely to cause legally recognised harm. Personation means pretending to be another person, knowingly substituting one person for another, or representing someone as a person they are not. The person impersonated may be real or imaginary. Riya's caller uses a phone and fake support profile, claims to be the platform's security officer, and says approval will reverse a fraudulent payment. In truth, it sends money away. The phone alone does not create Section 66 D. Examine the false identity, deception, inducement, resulting or likely harm, technological medium, and accused person's role. The punishment is imprisonment of either description up to 3 years, with liability to a fine up to 1 lakh rupees. Sections 66C and 66D often appear together, but they are not synonyms. If someone dishonestly uses Riya's password to enter her cloud account, Section 66C may arise even if nobody is induced to transfer property. If a caller invents a bank officer's identity and tricks Riya into sending money without using another person's credential, Section 66D may arise without 66C. In a phishing chain, both may apply. Stolen credentials occupy the victim's identity while a false message induces a transaction. Yet may apply is not must be convicted. Prove the identity feature and its use. Then separately prove personation, deception, inducement, harm, attribution, and the technological medium. If Riya recognises the call and sends no money, completed cheating requires careful analysis, while attempt or other provisions may remain relevant. An unsuccessful scam and a completed transfer are not identical. One artifact cannot prove everything. A log may show that Riya's credential was accepted, not who typed it. An IP address may identify a connection or subscriber, not invariably the user behind a shared router, VPN, compromised device, or mobile network. A call record links numbers, while speaker identity may need more. A bank trail shows where money moved, while control and knowledge remain separate. Strong attribution combines device forensics, account and platform logs, email headers, SIM records, transaction trails, lawfully obtained CCTV, communications, recovery evidence, and witnesses. Screenshots are useful leads, but original messages, full headers, URLs, timestamps, transaction references and device states may contain what screenshots omit. Electronic records must be proved under the Bharatiya Sakshya Adhiniyam with integrity and the statutory rote explained in Episode 3. Account attribution is not automatically human attribution. A case is built as a chain. Section 66. E does not criminalise every privacy invasion. A person must intentionally or knowingly capture, publish or transmit an image of the private area of any person without consent, under circumstances violating that person's privacy. Capture includes videotaping, photographing, filming or recording by any means. Transmit means electronically sending a visual image intending it to be viewed by one or more persons. Publish means reproducing it in print or electronic form and making it public. Private area includes naked or undergarment-clad genitals, the pubic area, buttocks, or female breast. Privacy-violating circumstances exist where a person can reasonably expect to disrobe without capture, or expect that a private area will not be visible to the public, whether in a public or private place. The provision refers to any person, although part of its anatomical definition is sex-specific. Punishment is imprisonment up to 3 years, or a fine not exceeding 2 lakh rupees, or both. Private photo alone is not enough. Consent attaches to the act analysed. A person may consent to private capture, but not transmission to a friend, group or website. Sharing with one recipient is not consent to public circulation. Section 66. E therefore separates capture, transmission and publication. The BNS voyeurism provision adds an adjacent rule for women. If a woman consents to capture of an image or act but not dissemination to third persons, later dissemination is an offence under Section 77 if its requirements are met. Section 77 covers watching or capturing a woman engaged in a private act or disseminating that image. Section 66. E is gender neutral but confined to its defined private area image and other ingredients. The provisions may overlap, but their scope and punishments differ. Consent is not inferred merely from an intimate relationship. Ask, consent to which act, for which recipient, in what circumstances and at what time. If an image is artificially generated or morphed, Section 66E cannot be applied by slogan. Ask whether the statutory image, act, mental element and lack of consent are proved. Other offences, civil remedies and intermediary rules may more directly address synthetic impersonation. A threat also needs precision. Pay or I will circulate this image is not itself the capture, publication or transmission required by Section 66E, although an earlier act may have occurred. Under the BNS, criminal intimidation may arise where a threat to person, reputation or property is intended to cause alarm or compel an act or omission. Extortion may arise where fear dishonestly induces delivery of property or valuable security. Payment changes the analysis. Refusal may leave attempt or intimidation. Take image-based abuse seriously without pretending that an unproved element exists. Separate Section 66 E from Sections 67, 67A and 67B. Section 66E protects bodily privacy through a defined private area image, lack of consent and privacy circumstances. Section 67 concerns obscene electronic material under its statutory test. Section 67. A concerns material containing a sexually explicit act or conduct. Section 67B creates specific, wider offences involving children, including stated creation, collection, browsing, downloading, distribution, facilitation, and recording conduct. A child means a person below 18. The categories may overlap, but answer different questions. Non-consensual circulation can violate privacy even when obscenity is a separate issue. Obscene material does not automatically prove a defined private area image without consent. If a child is involved, Section 67B and the POCSO Act may become central. Analyse content, age, act, consent, expectation and mental element. Obscene, explicit and private are not interchangeable. The copied file raises confidentiality questions, but Sections 72 and 72A have limited gateways. Section 72 applies where a person secured access through powers under the IT Act or its rules or regulations, then disclosed specified material without consent. It is not a general workplace leak offence. Section 72. A covers a person, including an intermediary, who obtained personal information while providing services under a lawful contract and disclosed it without consent or in breach of contract, intending or knowing likely wrongful loss or gain. Service access, disclosure and mental element require proof. The DPDP Act adds separate governance, but commencement matters. A November 13th, 2025 notification commenced institutional and rule-making provisions. Most core processing duties, rights and penalty provisions are scheduled for May 2027. Another group for November 2026. As at 29th July 2026, the framework is partly commenced, not fully operational. A current remedial route was strengthened on February 10th, 2026. Under updated Intermediary Rule 3.2b, after a complaint from the individual or someone acting for that individual, an intermediary must within 2 hours take reasonable and practicable measures to remove or disable specified prima facie content it hosts, stores, publishes or transmits. Categories include exposed private area, nudity, sexual act or conduct, and electronic impersonation including artificially morphed images. The period was reduced from 24 hours. This platform duty is not a judicial finding that an uploader committed Section 66C, 66D or 66E. Identify the content and link, keep the complaint reference, and preserve evidence lawfully. Quick removal protects the person. Investigators may still need original files, device data, platform records and transactions. Removal, preservation and criminal liability remain distinct. The first case is National Association of Software and Service Companies versus Ajay Sood, decided by the Delhi High Court on March 23, 2005. The case arose from fraudulent emails sent through fictitious identities while masquerading as NASSCOM, with the aim of extracting personal data for headhunting. Hard drives recovered through a court-appointed commission contained offending emails. The court described phishing as internet fraud, in which a person pretends to be a legitimate association, such as a bank or insurer, to extract access codes, passwords, or other personal data for advantage. But the procedural posture matters. The parties filed a compromise. The court accepted the settlement and passed a consent decree. This was a civil action involving injunction, misuse of identity, and related relief, not a criminal conviction under Section 66C or 66D. Those sections were inserted later by the Information Technology Amendment Act, 2008, and came into force in 2009. The case is therefore historically important for understanding phishing and online masquerading, but it must not be cited as though the court convicted Ajay Sood under provisions that did not yet exist. That single qualification separates careful legal teaching from a common internet myth. The second case is Justice K.S. Puttaswamy, retired versus Union of India, decided by a 9-judge bench of the Supreme Court on 24 August 2017. The central question was whether the Constitution protects a right to privacy. The court unanimously answered yes, recognising privacy as constitutionally protected and intrinsic to life, personal liberty and the freedoms guaranteed by Part 3. The opinions explain privacy through overlapping dimensions, including bodily integrity, control over personal information and decisional autonomy. The judgment also makes clear that privacy is not absolute. State interference must have legal authority and satisfy constitutional standards, including a legitimate aim and proportionality. Why does this matter here? Section 66. E is a statutory criminal provision with tightly defined ingredients. Puttaswamy supplies the wider constitutional understanding of dignity, autonomy, and informational control. It does not remove the need to prove capture, publication, or transmission, the defined private area, absence of consent and privacy-violating circumstances under Section 66E. Nor was Puttaswamy a prosecution about Riya's facts. Its role is foundational. It explains why bodily and informational privacy are legally serious, while the offence section still determines whether a particular accused person can be punished. The third case is Mrs. X versus Union of India, Writ Petition Criminal 1505 of 2021, decided by the Delhi High Court on 26 April 2023. The petitioner's explicit images remained available online despite complaints to websites, search services, and the cybercrime portal. The court explained non-consensual intimate images as sexual content distributed without the consent of the person depicted. The image may or may not originally have been captured with consent. It connected such dissemination to the IT Act and to the fundamental right to privacy under Article 21, and rejected the idea that privacy disappears inside a domestic relationship, or merely because an image was once shared privately. The court issued extensive directions and recommendations involving intermediaries, search engines, police, and media, so that victims would not be forced to chase each re-upload through repeated litigation. The case is highly relevant to Riya's threatened image, but states the limit accurately. It was a constitutional writ about effective removal and institutional response, not a final criminal trial, convicting the uploader under Section 66E. Its enduring lesson is remedial and rights-based. Consent to creation or limited sharing is not consent to uncontrolled dissemination, and online republication can cause continuing harm. The fourth case is Sharat Babu Digumarti versus Government of the National Capital Territory of Delhi, decided by the Supreme Court on December 14, 2016. It arose from the Bazy.com prosecution concerning obscene material offered electronically. The court examined Section 67 of the IT Act and former Section 292 of the Indian Penal Code. In that setting, the later Special Electronic Content Scheme of the IT Act, with its overriding provision, governed the overlap. Why include it? Intimate image facts tempt people to treat privacy, obscenity, sexual content, and general penal provisions as interchangeable. Sharat Babu teaches that the exact statutory scheme and electronic form matter, but it did not decide Section 66C or 66D or every overlap between the IT Act and current BNS. Distinct offences may coexist. Identify each proved act and ingredient before deciding whether provisions overlap, exclude one another, or address different wrongs. Now apply the method without accusing anyone prematurely. First, the old phone. Was it stolen? Who received or retained it? What facts show dishonest conduct and knowledge or reason to believe it was stolen? Only then does Section 66B enter. Second, Riya's password. Was it actually used, in which system, by whom, and with dishonest or fraudulent intention? Those are Section 66C questions. Third, the support call. Who created the false identity? What deception occurred? What was Riya induced to do, and what harm resulted or was likely? Did a communication device or computer resource carry the personation? Those are Section 66D questions. Fourth, the image. Does it depict the statutorily defined private area? Was it captured, transmitted, or published intentionally or knowingly? Did Riya consent to the relevant act? Did the circumstances violate her reasonable expectation of privacy? Those are Section 66E questions. Fifth, the demand. Did the threat cause alarm or compel action? Did fear dishonestly induce delivery of money or property? Those facts may engage BNS criminal intimidation, extortion, or attempt. The conclusion is not all cyber sections apply. The conclusion is a structured set of allegations, each supported or not supported by evidence. End with a usable response. First, protect the person and stop continuing harm. Secure compromised accounts, change credentials from a trusted device, revoke active sessions, enable stronger authentication, and alert the bank or platform through verified channels. If money moved in a cyber financial fraud, the government's portal directs victims to call 1930 promptly and register at cybercrime.gov.in. Speed can matter to tracing and holding funds. For intimate or impersonation content, use the intermediary's grievance mechanism, identify the content and links, and keep the complaint number. Preserve evidence lawfully. Original messages, full email headers, phone numbers, account identifiers, URLs, transaction references, timestamps, voice notes, and available device information. Do not repeatedly forward intimate material merely to prove it exists. Unnecessary circulation deepens the harm. Do not pay or negotiate a loan because the offender demands secrecy. Seek appropriate police, legal and trusted personal support. Document password changes, bank calls, platform complaints and acknowledgements. Protection, removal and preservation should move together. For examination, practice or incident analysis, use 8 questions. 1. What is the legal object? A stolen device, identity feature, false representation or intimate image. 2. What precise act occurred? Receive, retain, use, impersonate, deceive, capture, transmit, or publish. 3. To whom did the device, identity feature or image relate? 4. What permission, authority and consent existed and where did each end? 5. What mental element is required? Dishonestly, fraudulently, intentionally, knowingly, knowledge or reason to believe. 6. For personation, what deception, inducement and harm completed the cheating analysis? For privacy, what reasonable expectation and defined body area approved? 7. Who is the human actor rather than merely the named account number or device? 8. How were records preserved, connected and proved? Then check adjacent law. Sections 67 to 67b for content. Sections 72 and 72a for defined confidentiality situations, the BNS for personation, extortion, intimidation, voyeurism or stalking where their own ingredients fit, the intermediary rules for removal, and the staged DPDP framework for data governance. The order never changes. Facts, ingredients, provision, proof. Your digital identity is not one thing. It is a chain of devices, credentials, representations, relationships, and expectations of privacy. The law protects different links through different rules. Section 66. B targets dishonest receipt or retention of a stolen computer resource or communication device with the required knowledge. Section 66. C targets fraudulent or dishonest use of another person's electronic signature, password or unique identification feature. Section 66. D targets cheating by personation carried through a communication device or computer resource. Section 66. E targets intentional or knowing capture, publication or transmission of a defined private area image without consent under circumstances violating privacy. Around them sit other provisions, but none should be added without its own ingredients. Riya's story also reveals the next legal question. What must a platform do when unlawful content appears? When can an intermediary claim safe harbour, and when can that protection be lost? How do notice, due diligence, removal and preservation interact without turning a private company into the final judge of guilt? That is episode 6. Platforms, safe harbour and intermediary liability under section 79. This is Beyond Bare Act, what the law says and what it does.